Welcome back to the third hour of Ring of Fire Radio. I'm Sam Cedar. This next interview was recently recorded at the Mass Torts Made Perfect 2018 conference in Las Vegas, Nevada. The purpose of the MTMP conference is for trial attorneys to come together and share information on some of the biggest cases in the country. Here's an interview I did with a former tobacco defense attorney, Bethany Schneider, on why she made the switch to become a consumer advocate. We're continuing our coverage of the 2018 Mass Torts Conference in Las Vegas, Nevada. I am joined by Bethany Schneider of her newly opened firm, Bethany Schneider.
Schneider Law PC.
Schneider Law PC. All right, so Bethany, you have an interesting story in that your career up until very recently has been defending attorney as opposed to a plaintiff attorney, and you defended big tobacco. Give us a sense of the cases that you dealt with.
Sure. For the last 6 to 7 years, I've been working on the Engle progeny litigation in Florida, which stemmed from the Engle class action that was tried in the 1990s that went up to the Florida Supreme Court and was decertified as far as liability and damages went. So,
what does that mean, decertified?
So basically, the class action was broken up, and the Supreme Court of Florida said that each plaintiff had to go in an individual lawsuit and prove liability and damages, although they would get the benefit of certain findings that the Engle jury made in the 1990s, which included things like tobacco companies were negligent. They sold a defective product that was more unreasonably dangerous than it had to be. Nicotine is addictive. Certain findings that basically were already established in the case that the plaintiff's lawyers did not have to reestablish, but that each individual plaintiff had to prove certain things like whether they were addicted and medical causation for their disease, and then had to prove their own damages, punitive damages, things like that.
Oh, so what changed? I mean, how that decertify? What is the standard to decertify a class? So it's really sort of like a procedural issue, and then it gets broken up into the specific case.
Well, the Supreme Court found that there were too many individual issues related to liability and damages in these cases that it could not be decided. Those specific issues could not be decided on a class-wide basis. That's why we have things like MDLs, is because, they're
MDL is
multi-district litigation, where and mass torts, right, where it's not necessarily a class action where you're going to try all the cases at once. It's where individual plaintiffs are part of a larger group and the litigation is going on and there may be findings that apply, but that each specific case is a different case because there are too many individual issues on causation and damages to be tried together.
In your experience, is it your sense that the standards for being able to have a class action have narrowed so that decertification of the type that you're talking about is more likely to happen now? Like, in to a certain extent, that is that could be characterized, I think, in my opinion, as sort of making the doorway to the courthouse a little bit narrower for people. I mean, is that fair?
I mean, I can't speak to how it's changed over time. Certainly in the types of cases that we're seeing dealing with drugs, medical devices, things that affect people differently, there certainly is much more narrowed view of class actions. I mean, you're seeing more class actions on the consumer side. So it's not a lot of causation issues, it's not a lot of individual issues, but certainly when you're dealing with medical histories or damages, then it's going to be a much, narrower ability to say, oh, everybody was affected in the same way and everybody was damaged in the same way.
So when you're a defense attorney and you're dealing with that case and it's decertified, you're happy, yeah, because you know that you have more resources than perhaps these individual plaintiffs. Is
right. I mean, if you see for the Engle progeny case, or the Engle case, when it was decertified, there were 5,000 plaintiffs that were signed up. So then, as a defense lawyer, saying, okay, all these people are going to have to go and prove their own case, and that's going to take a really long time. In fact, I think there was some estimate that it would be like, 22-33 by the time all these cases would get tried. And that's certainly much more favorable to the defendant than it is to each of these individual plaintiffs.
And you're working for tobacco, and they have a lot of cash. I mean, isn't that part of the dynamic too, that the defendants feel like not only is it if I have to pay out all 5,000 of these cases, which is unlikely, but if I do, I'm able to extend the period of time that I have to pay that out, but I've got the resources. So those 5,000 people, like, how many will end up, let me put it this way, how many of those 5,000 will end up actually pursuing cases against that defendant?
I mean, I think it just is a matter of, how long it takes. Now, it's not only, we have enough, money to push it out. It's that there's no way a settlement would be possible. These are $50 million cases. I mean, right before I left King & Spalding, there was a $42 million verdict I wasn't involved in, but that's how valuable these cases are. Now, there are also defense verdicts, but there's no way it would bankrupt the company to have to pay out a settlement. You would not be able to come up with a settlement figure that would adequately compensate the people who deserve compensation, while also compensating maybe people who don't deserve it as much. Because certainly in those 5,000 cases, there are some cases that aren't worth as much as other cases. And so it would just be impossible, really,
well,
to come up with a settlement.
All 5,000 of those people who were involved in a class action suit, which is much less onerous to those individual plaintiffs than going and bringing their own case.
They weren't involved in the class action because there were only a few named plaintiffs when the class action happened in the 1990s. So when it was decertified, there was a year where plaintiffs were allowed to sign up. And so that's when all those people signed up, once it was already decertified. They signed up knowing they would have their own individual case.
Wow. All right, we've got to take a quick break. When we come back, we're going to talk to Bethany Schneider about her decision to leave the defense side of this and start a plaintiff practice and what cases she intends to pursue. We'll be right back. Ring of Fire Radio. I'm Sam Cedar. We are in Las Vegas, Nevada for Mass Torts 2018. We'll be right back after this.
Well, maybe it's the common curse. Maybe things get bad before they get worse. I don't want to become someone who can't live up to what I already done. Don't keep it just to figure it out. Well, it rains and pours and then it runs out. I was crying on the bathroom
Welcome back to Ring of Fire Radio. I'm Sam Cedar. Right now we're listening to an interview I recorded last week with former defense attorney Bethany Schneider on her switch to become a consumer advocate. With me is Bethany Schneider. She was a defendant's attorney for about 7 years.
8.5.
8.5 years. At least part of that was defending big tobacco. And you have since left the defense side of things to become a plaintiff's attorney. Why?
So over the last year, I realized that over the course of the 24 trials I'd been to, I had done everything in the courtroom except pick a jury. So I felt like I had built the skills I needed to be able to figure out, okay, what is my career going to look like? Do I want to be a defense lawyer? Do I want to spend my career defending corporations? Because as we all know, the longer you stay at a big law firm, the tighter those golden handcuffs are going to be. And so I felt like this was the perfect time to really do soul searching to see how I wanted to spend the rest of my life and how I wanted to use the skills that I had built at King & Spalding and doing the tobacco litigation, which was excellent training for a younger associate, and decided that where my heart really was in the plaintiff's side. I mean, when I went back and watched some of the openings and closings that I did on the defense side, I felt like the characteristics that I think are going to make me a great lawyer: passion, emotion, compassion. Those are the things that I think really are more plaintiff lawyer characteristics.
I want to tease that out because, I've been coming to this conference for, I don't know, 7 years. And there's some folks here who, are pursuing, making a lot of money as plaintiff's attorney. But there's a lot of folks here who have a deep commitment to social justice. They're a pretty healthy anti-corporate streak. Just tease that out. I mean, when you say you feel more comfortable going in, what does that actually mean?
Well, I mean, so as a defense lawyer, your job is to deflate the emotion, stifle passion, really try to take all of that out of the courtroom. And what I was seeing when I was looking at
dehumanize it on
exactly,
something, right?
Exactly.
Because the victims are always people, and you want to keep the jury from being conscious of that.
Right. I mean, you want to be, yes, very much more like logic, common sense. You're not going to want to do anything that's going to make the jurors feel anything. I mean, there on some aspects in the tobacco litigation, as there are in other litigations, there was a lot of personal choice type arguments where that was an area where you could kind of use some emotion. But for the most part, you're wanting an emotionless jury as they're going in, especially when you're dealing with different sympathetic cases and sympathetic plaintiffs. So what I saw was that that was going to be something that I thought was my most valuable asset, which was my empathy and passion and emotion, and I was basically being critiqued for that on the defense side. And so I do feel for people, and I just in the 7-8 weeks I've been on the plaintiff side have felt so much more fulfilled being able to talk to individual clients. I mean, starting out I'm doing pretty minor cases, but just the amount of self-satisfaction you can feel in helping somebody, and I've said, I wanted to take my Goliath type skills and help the Davids, go up against the Goliaths. And I think it's really been fulfilling for me. And I do feel that sense of social justice and trying to fight for what's right.
It's interesting because one of the other sort of reoccurring themes that has come up over the years is as different attorneys in different types of cases, whether it was tobacco cases, and obviously you're familiar with a lot of the documents that came out in discovery, and we were talking before that these are decisions that were made 50 years ago, so it's tough for you to get an insight into what was going on in those minds. And I've talked to attorneys here who talk about the story of Remington rifles and rifles that were shooting without anybody touching them, killing people. The company was aware of it. The company was aware of it is up until very recently. Were very sort of like was issued a recall in a very subdued manner. Do you have any insight into the mentality? I mean, because you talked about you had pressure as a defense attorney to dehumanize the situation in the courtroom. And it seems to me that there has to be a certain amount of that goes on within the boardroom when they're making these decisions that are ultimately like, okay, X number of people are going to die, X number of people are going to get maimed, but on the other hand, our profits are going to be X plus. And so if we have to pay out some of this, do you have any insight into that? Because that is the one question that always I can't wrap my head around.
I think it's the same story that happens now, with different corporations, even, at different companies, where people get so insulated or isolated from the outside world that when they're looking at questions of profitability versus safety, somehow they're just able to make the decision for profitability. I mean, it's interesting because in the tobacco litigation, all of those executives who are making the decisions to, keep it secret that it, was harmful or not addictive, were also smoking, and their families were smoking. And so it's like, it's one thing if, they all quit smoking and then kept on saying, it's it's not an issue. But it seems like in a lot of these things, somehow these corporations are just convincing themselves to the point where they believe it, that what they're doing is either justified or they don't want to believe it, or but I think that we're always going to have mass torts. We're always going to have these types of products because people are always going to make the decisions to put money over people, and it's amazing that it continues.
What are the types of cases that you're looking to pursue in your practice? I mean, I know it's early, but I'm just curious as to where.
Eventually, I would like to do catastrophic personal injury and wrongful death cases. Specifically, right now, in trying to find my niche as a female lawyer, I'm specifically interested in sexual assault cases. I think there's a big hole in the Atlanta area for a lawyer taking those types of cases. I'm also interested in the talc cases.
The talc cases?
Yeah, the talcum powder cases that Mark Lanier spoke about earlier today.
Just tell us those. Tell us what the talc cases are, because I don't think the audience necessarily knows.
Yeah, it's the Johnson & Johnson baby powder that they used. Talc, there's two different kinds of cases. One was a huge verdict yesterday in New Jersey that involved allegations that that talc contains asbestos and caused a male's mesothelioma. And so a jury awarded $80 million
wow.
in that litigation. And there's also another line of cases specifically for females in that it causes ovarian cancer. And so there's been kind of different verdicts in those cases.
That was one thing, too, that I was aware of when my children were babies, is don't use, it's called baby powder, yet horribly dangerous for babies.
I think
that seems problematic.
Yeah. I think right now it's been really more, females using it, as an adult. But I'm not sure that there's a line of cases yet on whether, how it affects babies. But
okay, well, thank you very much for joining us. If people want to know more about your firm, where would they go?
My website is www.schneiderlawpc.com. And then I also have, LinkedIn and Facebook. So Bethany Schneider, Schneider Law PC.
All right. Well, thank you so much for your time, Bethany.
Thank
I really
you.
appreciate it.